The details of obtaining consent for a search can drastically alter the outcome of a criminal case, as seen in the 1995 motion to suppress evidence in the state of Tennessee versus James Dellinger and Gary Sutton. Here, a seemingly straightforward consent form became the focus of intense scrutiny, questioning whether a police detective truly obtained voluntary permission from a witness.
That's right, Lily. This hearing on May 15, 1995, before Judge D. Kelly Thomas, Jr., centered on a crucial question. Was the evidence found on the Dellinger property legally obtained? The state called Chief of Detectives Dale Gorley, who testified about seeking permission from Angela Gray to search her trailer.
Chief Gorley claimed he approached Miss Gray on February 28, 1992, at her trailer in Sevier County. He described the conversation as brief and, quote, very low-key, end quote, with no confrontation. He stated he asked to search her trailer for any weapons or anything, and that she agreed without hesitation or questions.
He said he filled out a consent to search form, which Ms. Gray signed in his presence. Importantly, he testified that she showed no reluctance or concern. As a result of that search, officers found spent shotgun shells in the area around her trailer.
But the defense counsel, Mr. Dees, really probed Gorley's recollection. He pressed on the sequence of events, asking if the search of the main Dellinger trailer was already underway when Gorley approached Angela Gray. Gorley's memory seemed quite hazy, frequently stating, quote, I don't recall, end quote, or, quote, probably, end quote, when asked about specifics.
Exactly. Mr. Dees highlighted that Gorley couldn't definitively say whether Gray's trailer was searched first or if Detective Widener was present throughout the entire conversation with Miss Gray. He also questioned the specificity of the consent. Gorley admitted he didn't use the word yard, but rather said he wanted to, quote, look around, end quote, outside the trailer.
That phrase, look around, seems incredibly vague when discussing consent to search a property. And then there's the critical question of whether Angela Gray was informed of her right to refuse. Gorley stated he did tell her she didn't have to consent, explaining she didn't have to give permission, but he would, quote, appreciate it if she would, end quote. He also claimed he read the form to her, but that directly contradicts what Angela Gray later testified.
Yes, Angela Gray's testimony paints a starkly different picture. She was called as a witness for Mr. Dellinger. She described her personal circumstances on that day. She was 22, had a ninth-grade education, was separated from her husband, and had a 2-week-old baby, Joey, who had recently undergone surgery. She was anxious about his health, and she and her family had received threats related to the murder investigation of Tommy Griffin. Their homes had even been shot at prior to February 28th.
So she was in an incredibly vulnerable and stressful situation. She described seeing numerous armed officers and detective cars at her stepfather's trailer, where she was present during the search. When Chief Gorley approached her, she claimed he told her to read the consent form and sign it, but she only read part of it. Critically, she felt she didn't have a choice in the matter, stating, quote, I felt they could do it anyway, end quote. She also explicitly testified that Gorley did not specify what he was looking for or that he intended to search the yard.
Her account directly challenges Gorley's claim of a low-key conversation and fully informed consent. She stated that Gorley asked her address, filled out the form, and then gave it to her to sign, implying the terms were already set. She understood they wanted to search the trailer, but not the broader property.
The contrast between the two testimonies is striking. Chief Gorley's recollection was vague on key details, while Angela Gray, despite the passage of time, provided vivid personal details highlighting her state of mind and perceived lack of choice. This isn't just about a he said, she said scenario. It's about the legal standard for voluntary consent. If consent isn't freely and knowingly given, any evidence found could be deemed inadmissible.
Exactly. The defense was trying to establish that Ms. Gray's consent was not truly voluntary, given her distressed state, the overwhelming presence of law enforcement, and her feeling of compulsion. Her limited education and the non-specific nature of Gorley's request further weakened the prosecution's claim of valid consent, particularly regarding the search of the area outside her trailer where the shotgun shells were found.
This case really underscores how crucial every interaction between law enforcement and individuals can be, especially when it comes to fundamental rights like protection against unreasonable search and seizure. If you found this discussion insightful, consider sharing it with someone who might also find it thought-provoking.